Hello, this is Paul Callahan. Welcome to our latest webinar, a European Legal Update. Today we're going to be looking at some really topical issues focused on both employment law and commercial law with a look at GDPR and what's happening there as well. Inevitably, given that we're about 16, 17 days from a supposed Brexit, we're going to be focusing a fair bit on Brexit, where we are with that, what you need to be thinking about, if anything. We're also looking at the metoo movement and how that's impacting Europe, and in the broadest sense, so looking at gender pay and pay equity issues as well as sexual harassment issues. And we're also looking at non-competes, which are always very important in Europe, but in the UK in particular, there's a Supreme Court case which might significantly impact non-competes and might mean that most companies should update any non-competes that they currently have. So let's start by looking at Brexit and where we are with Brexit now. And my colleague Roxanne Davey is going to talk through some of the employment and immigration law issues for you to think about. And just today, Theresa May has come back to the House of Commons with a slightly revised deal from the EU. If that deal were to be passed by Parliament tonight, it would mean that we'd go into a 2-year transition period where effectively very little would change in relation to the UK's relationship with the EU. As of now, it's looking very unlikely that will pass. The pro-Brexit group have made it clear that they're going to vote against it, and those MPs who are against any Brexit have also said they're going to vote against it. So to some degree, we're guessing what is going to happen. But at the moment, it looks like there may well be a delay to any Brexit at all, although there is always the possibility that the UK just leaves on March the 29th with no deal, with no deal at all. In that sort of scenario, the government has said that they will massively slash any tariffs on incoming goods and look to deregulate to make the UK even more competitive and more business friendly. But most MPs have said that they're against a no-deal Brexit, and there'll be a vote on that on Thursday, assuming that today's deal gets voted down, in which case, and that will probably rule out a no-deal Brexit. But you've got to keep watching because we just can't be absolutely sure at the moment. But I'll hand over to Roxanne now, who in any event will tell you what you need to be thinking about in terms of employment and immigration law issues.
Thanks, Paul. Hi, everyone. So if we first of all look at the employment considerations, we're expecting very limited immediate change in the employment field, and that's unlikely to be impacted whether or not we've got a deal or no deal Brexit. So after the Brexit vote, Theresa May guaranteed workers existing rights, and as recently as last week, the government issued a press statement to say that Parliament would be given a vote on adopting future EU rules on workers' rights. So the aim seems very much to be protecting and improving workers' rights after the UK leaves the EU. One thing that we know will change is that the statutory framework for European Works Councils will cease to apply, but other than that, there is no immediate changes planned. There's always the chance that after after Brexit, the UK has the opportunity to become even more business friendly. And shortly after the initial Brexit vote, much was mooted about whether or not there might be amendments to TUPE or changes to collective redundancy law. That remains to be seen, and it's largely going to depend on the government which is in place at the time. But for now, there's nothing immediately to be aware of from a straightforward employment context. Turning to immigration, this is an area where there are potentially significant changes affecting the rights of EEA nationals in the UK. It's important to note that this doesn't impact non-EEA nationals, and so for those that are here under visas under the points-based system, those rules will continue to apply and they'll be unaffected by these changes. So on the screen there are 3 key considerations for you to bear in mind from an immigration perspective. One is whether you've got EEA nationals working as part of your UK workforce. 2 is whether you've got UK citizens working elsewhere in the EU. And 3 is in relation to business travel between the UK and the EU. We'll be looking at number 1 today, but we are holding an immigration-specific Brexit webinar this Thursday, and we'll be going into much more detail then. On your screen, you should be able to see a resource list, and you can use that to sign up to that webinar. Okay, so the key issues for EEA nationals working in the UK. First of all, what do we mean by the EEA? For these purposes, we're thinking about European nationals, plus those in Norway, Iceland, Liechtenstein and Switzerland. So Brexit itself will not invalidate the right of EEA nationals to live or work in the UK after the 29th of March, but they are going to have to apply to protect their rights. To be clear, there is no possibility that an EEA national will suddenly be in the UK illegally and will be forced to stop working shortly after Brexit. But as we're going to explain, they will need to take some steps. The scheme that's been put into force is called the EU Settlement Scheme, and that's going to be available whether there's a deal or no deal Brexit. But if there is a no deal Brexit, then the rights under that scheme are going to be watered down. Plans to charge £65 for the EU Settlement Scheme have been scrapped, and so it's now free. After December 2020, which is the end of the transition period that Paul mentioned earlier, a new immigration system is going to apply to EEA nationals. We don't know exactly what that's going to look like yet, but we're expecting it to be a points-based system, as we have with non-EEA nationals currently. So, the EU Settlement Scheme is a new immigration scheme, and it's intended to preserve the rights of EEA citizens and their families that are resident in the UK before the 31st of December 2020, which is the end of the transition period. You should be able to see an immigration timeline on your screens, and as you can see, we've got the first item there, the 29th of March 2017, when Article 50 was triggered. Next item is the 21st of January 2019, when the voluntary public testing phase of the EU Settlement Scheme opened. We've then got the 29th of March, which is the date on which the UK is intended to leave the EU, unless Brexit is either delayed or cancelled. And the EU Settlement Scheme fully opens the next day on the 30th of March. As mentioned, there's a proposed transition period which will run from the 29th of March until the 31st of December 2020. Rights of EEA citizens in the UK should remain unchanged until then, and if there is a no-deal Brexit, that will be the deadline by which EEA nationals will need to submit their settled status applications. If there is a deal, then that deadline is extended to the 30th of June 2021. And as of the 1st of January 2021, we're expecting a new immigration system and new rules for EEA nationals arriving from that date. So what is the EU Settlement Scheme? So as we know, the automatic right of European citizens and their families to live, work and study in the UK is going to end with Brexit. But the EU Settlement Scheme aims to preserve rights, and some of the things that it will enable those working under the scheme to do will be to live, work and study in the UK and travel freely in and out of it, to use public services such as the NHS and schools, to access public funds such as benefits and pensions if they're eligible, and to apply for British citizenship. It's an online scheme, and there are kind of two tranches to it. The first is for straightforward settled status, which is similar to permanent residency, and you can apply for that if you've been in the UK for 5 years or more. Once an individual receives settled status, there's no time limit on how long they can stay in the UK. The precursor to that is pre-settled status, and so individuals can apply for that if they're not yet eligible for settled status. That gives individuals a 5-year temporary stay in the UK and can lead to settled status. And there's no minimum period of stay that individuals need to have been in the UK for before they can apply for pre-settled status. The scheme is fully operational from the 30th of March 2019, and it's an online scheme which is intended to be much simpler than the pre-Brexit permanent residency scheme. Individual statuses under the scheme are recorded electronically, and they are given an online profile, so it means that no one receiving settled status will be receiving paper documents or biometric cards. Instead, everything's going to be recorded online. So who can apply? As mentioned, citizens of the 27 EU countries and also Norway, Iceland, Liechtenstein and Switzerland. It's optional for Irish citizens to apply due to special arrangements between Ireland and the UK, but what's important is that all applicants should be resident in the UK. So applicants for settled status no longer have to be exercising treaty rights as under the current permanent residency requirement. Instead, they just need to have been resident in the UK for the last 5 years, as the focus under the new test is very much on residency as opposed to the individual's activities. It's also important to note that even those who already have permanent residency must apply, or alternatively, if they're eligible, apply for British citizenship. So making an application, it's a digital process, so people are asked to do it online, and the Home Office is going to verify the information supplied through various government agencies such as HMRC. The deadline for applying under the EU settlement scheme varies depending on whether or not there's a deal or no deal. So if there is a deal, the deadline is going to be the 30th of June 2021, but if there's no deal, that's reduced to the 31st of December 2020. The three-stage test, the first being identity. So individuals will need to upload a photo of themselves and they can scan their EA passport for that purpose. Second is eligibility and residence, and for that it's intended that they would just need to upload their national insurance number, though some further detail may be required. And finally, they will need to declare any previous criminal convictions for the suitability element of the test. So the test is the scheme is now going to be free, and as mentioned, when it was first considered, the government suggested that a £65 application fee would be payable for adults. So that decision has now been reversed, but it's important to note that if individuals apply before the scheme fully opens on the 30th of March, they might still have to pay the fee by card, but ultimately it will be refunded to them. So as I mentioned, we have a dedicated BREXIT immigration seminar on Thursday, and you should be able to sign up for that using the link on the screen if you haven't been able to already. We've also got a dedicated immigration team that are providing the full range of BREXIT solutions, be that by way of materials or individual clinics. So please do let us know if you're interested in any of those. Changing tack slightly, we've also got an update here on subject access requests post the GDPR. This isn't entirely Brexit related, but we thought it would be useful to give you an update as to what we've been seeing in relation to subject access requests since the GDPR came into force last May. Generally speaking, they are on the rise. They're increasingly common when employment litigation is contemplated, and we're seeing them more and more. They're really, as far as we've seen, being used as an attempt to obtain early disclosure and to encourage employers to settle when there's likely to be a dispute or parties are in the early stages of a dispute. Post-GDPR, there were some changes to the subject access request regime. So the 40-day response timeline was reduced to 30 days, and employers are now no longer able to charge the £10 fee for processing the request. In terms of the approach that the ICO has taken to these requests, we've seen them being quite pragmatic. And in our experience, as long as employers are prepared to explain to the ICO exactly what they've done in relation to search terms and the approach to the request and the rationale for that, we've seen the ICO take a fairly balanced approach to dealing with complaints. So the key takeaways we would suggest are that if you're receiving a fairly onerous request and you are thinking about ways in which to apply search terms and criteria to try and obtain relevant results, we would suggest that you document the searches you undertake and why, and are prepared, if the ICO asks you to do so, to justify the approach you've taken. This should be helpful for demonstrating compliance and proportionality if the ICO asks you any questions about this.
Okay, thank you, Roxanne. And I should say, if you've got any questions you want to ask at any time, there is a box on your screen where you can ask questions, and we'll answer them at the end. Linked to both the Brexit discussion and to talk of GDPR, so a nice segue into the two bits that Roxanne spoke about. We have Sian Skelton, who is not an employment lawyer, is a privacy and commercial lawyer, and she's going to talk a bit more about data transfers generally and the impact of GDPR, or Brexit on GDPR, and what you may have to do if you want to transfer data to and from the UK if we do actually Brexit later this month. So Sian, over to you.
Thanks, Paul. Good afternoon or good morning, wherever you're situated. So as Paul mentioned, obviously we are hurtling towards possible Brexit, and in terms of data, there are yet more changes for you to be thinking about and preparing for in respect of the consequences of Brexit and data issues with the UK. So unfortunately, while we all thought the GDPR was done and dusted last year, it's a continually changing landscape, and something that businesses need to be aware of, regardless of where you're situated, and indeed the type of data that you're talking about. This applies to, employee data as well as your customer data. So all, again, just as a reminder, GDPR applies to all personal data, so it's definitely something that all businesses need to be thinking about. So what do we know at the moment? We know that the GDPR has been adopted in the UK under the Data Protection Act 2018. It's been well received. And most businesses have gone to great lengths to ensure that they are complying with the Data Protection Act 2018. Given that we knew that Brexit has been coming for a number of years, the government has been trying to grapple and give continuity to businesses around the data issue, especially in light of the fact that it's a changing landscape, or it has been over the last couple of years in respect of GDPR. So with respect to the Data Protection Act 2018, specifically, the government has confirmed that it does not, for the time being, envisage that they'll be making any changes to that particular piece of legislation as a result of Brexit. Furthermore, the government has confirmed that even after Brexit, the UK will be committed to a high level of protection for personal data that UK businesses process, because it's personal data relating to individuals based in the UK, or that UK businesses are processing as a result of their business on an international basis. So I think the takeaway message from the information we're receiving from the government at the moment and from the regulator is that we shouldn't expect to see a dumbing down of data protection legislation in the UK, and indeed that they will continue to maintain it and keep consistency of that legislation. And while we all may moan and roll our eyes around data protection, actually it's important that we do try and maintain that as much as possible, and in particular in line with Europe. Otherwise, we find ourselves in a particular situation where we are out of step with our European countries, and again, it makes life for just doing day-to-day business in respect of data and data transfers, which is what I'm going to come on to talk about, much harder. In addition, the UK government have also said that on or around the date of Brexit, that they'll be adopting a draft data protection, privacy and electronic communication regulations, and they'll come into force shortly after Brexit, whenever that might occur, be it at the end of this month or in 2 years' time. These regulations are also similar to what is being in draft in Europe as well, and I think it's an indication that the UK government are very keen to ensure consistency across the board with Europe. An area that businesses need to start thinking about in light of Brexit is data exports and imports. With the UK being part of Europe, we've never had to consider importing and exporting data, personal data, between European countries before, because we've always had the benefit of being part of Europe and also for the GDPR to apply. With the possible outcome of Brexit, the likelihood is that we will be considered to be a third country in respect of data transfer. What this means is that the European Commission and Union haven't determined that we have adequate protection in respect of the data and data transfer and how we maintain personal data, notwithstanding the fact that we have implemented the GDPR and that we do have the Data Protection Act 2018. The European Union haven't said officially that we have adequate protection, and therefore we'd be considered to be a third country. There is a mechanism in the European Union to allow for adequacy. The European Union have deemed that 12 countries, for example, Canada and Israel, have adequate protection for personal data, and therefore they have been given adequacy status in respect of the personal data that is transferred to those countries. This means that when thinking about data import and export, nothing further needs to be done in respect of ensuring that for example, whether additional contractual terms need to be put in place in respect of that data import and export, because that country is deemed to have adequate protection. It's the intention of the UK government to seek adequacy and adequate protection from the European Union. The European Union has indicated that it will likely give the UK that adequacy rating, but it's unlikely that the UK will get this before 2020. So it's likely that we, especially if we leave Brexit, if we Brexit from the European Union this month, it's likely that we'll have a period of time where we are deemed to be a third country and we do not have an adequacy ruling in our favour. And this then leads us to think about what this means for personal data and transfers. So when we think about data transfers, we need to think about it from two different, we need to think about it from an import and an export perspective. So at its most basic level, data exports from the European Union to the UK will no longer be protected. This means that that European countries and companies that are sending personal data to Europe, whether that's in receipt of services or because the UK company is the European HQ, or because all data is accessible by the UK company as well as its worldwide parent, will need to be sent in a method that allows for an adequate protection in respect of that data transfer. The way we go about achieving that adequate protection is to put what is referred to as standard contractual clauses, which is also known as SCC, or model clauses in place between the particular companies to ensure that the data transfer is happening properly. So just to recap, if you're a European company and you're transferring data to the UK, you should put in place model clauses. What about if you're a UK company and you're transferring data to Europe? What should you do there? The position on that is that actually the government have said that they recognise the European Union as providing adequacy, and therefore no additional contractual clauses are required in that respect. So in that way, you can continue. If you're a UK company and you're transferring data out to Europe, you can continue as you have been doing. What about data exports from the UK to the USA? If you've got Privacy Shield, or a US business and you have Privacy Shield certification, the UK government have said that the UK companies will continue to get the benefit of the Privacy Shield, the EU to the US Privacy Shield and that you can continue to operate as you have been doing. US companies that have US privacy shields will need to update their privacy shield registration to reflect the fact that data is being transferred from the UK, that they will also need to update their privacy policies, in particular the privacy shield statements in their privacy policies, and obviously any HR policies will also need to be updated. For those US businesses that aren't Privacy Shield registered, the position remains the same, and standard contractual clauses or model clauses should be put in place to regulate that data transfer. So, what do businesses need to do now? So, in a similar way to when we were back looking at GDPR and what that actually meant, businesses now need to look at data transfers in particular. Again, they need to be assessing the data transfers from the European Union to the UK. If you're Privacy Shield registered, you need to ensure that you're updating your certification and your privacy policies and HR policies to reflect the additional data transfer from the UK to the US. And you may also find that you're getting increasing conversations from customers and clients about data protection, data transfer, and where you're retaining your data. In order to do that, you need to make sure that you understand where your data flows are and how they operate to be able to have a sensible conversation about protections that you put in place. Of course, if you've got any specific questions, I'm very happy to help and answer any of those. Thank you.
Okay, thank you, Sean. So that's enough on Brexit for now. Maybe we should have another one next week where we might have a very different story on Brexit. Maybe it'll have been called off by then, who knows. But so moving on to a different subject, Mike Chattel is about to speak to us about enforcing post-termination restrictions in Europe. Non-competes in particular have very different rules in every single country in Europe, and they're increasingly common and often enforceable, particularly in the UK. But there is a case that's been heard in the Supreme Court, and we're awaiting judgment, which might impact on essentially the drafting you need in a non-compete to make it enforceable. And if the decision of the Court of Appeal in that case is upheld, it'll essentially mean that certainly everybody should review any non-competes that they currently use, and most people are likely to have to need amended ones because previously there would have been no way of knowing that what this case has said is required was required. So only a minority of companies are actually likely to have non-compete provisions that comply with the rule if it is upheld. But over to Mike to explain more.
Thanks, Paul. Yes, so as Paul mentioned, we're talking about enforcing post-termination restrictions as a whole across Europe. So we'll talk about both the UK and continental Europe. This obviously is a very complex subject and is subject to differing laws in every single country across the EU and Europe more generally. So this will be a more high-level overview look at the topic and really providing you a signpost to kind of issues you need to be considering when looking at post-termination restrictions. So looking at the UK first, and going back to basics, in principle, post-termination restrictions are fine in the UK, but they must meet certain fairly strict requirements in order to be enforceable. Now, I've set out there on the slide in front of you a very basic look at what these basic requirements are in order for restrictions to be enforceable. Firstly, there has to be a legitimate proprietary interest that is appropriate to protect. By this we mean that it isn't just enough to want to be able to stop an employee from competing or from acting anyway against you. You must have a particular interest and a specific interest which you want to protect. These interests are usually set out into three different categories. So there's trade secrets and confidential information, which is fairly self-explanatory and is one of the more common bases in which to base restrictions. There's customer connections, so knowledge of customers employees have or relationships, and stability of the workforce, which is mainly used for to justify non-poaching restrictions. And then secondly, that the protection sought is no more than is reasonable for having regard to the interests of the parties and the public interest. So this effectively is saying whether or not the protection that you're putting in place, the restriction you're putting in place, is no more reasonable or goes no wider than is necessary to protect the interest that you're seeking to protect. Now, this is a very fact-specific question, and it really does turn on a case-by-case basis. So what you need to be doing is making sure that you are able on an individual basis to justify the restrictions you're putting in place for that employee, rather than just putting in place a blanket set of restrictions for all employees. You need to be able to justify it on a case-by-case basis. And when you're looking at how you, or what exactly you're looking to justify, you're looking at a number of different areas, such as the duration of the restriction. So in the UK, 12 months is the absolute maximum for employees that you're able to enforce. But obviously the longer a restriction is, so the closer it is to that 12 months, the harder it is to justify. So you need to be able to just be comfortable that you can justify the length of the restriction for that particular employee. And then also geographical extent, so does the restriction, for example, cover areas that the employee hasn't been involved with? If so, you're going to struggle to be able to justify why that restriction is necessary. And then also, is there what's called a backstop period? So by this, for example, if you're having a non-solicitation restriction, you only want to apply it to customers, for example, that the employee has dealt with in the past 6 months or 12 months or whatever period it is. You can't basically have a very wide restriction that applies to every single customer, for example, that they've ever dealt with whilst being employed by you. Because if that interaction was 5 years ago, for example, it probably won't be relevant or able to form the basis for the justification of the restriction. So on restrictions, the courts, whilst they will enforce them where appropriate, they are rarely forgiving, and they won't give second chances on the drafting and range of restrictions. If they review a restriction as unreasonable, they won't look to redraft it to make it more reasonable. They will, in the vast majority of cases, just strike it out completely, which will obviously mean that you're left without any protection at all. So it really means that it's important to get it right to begin with, and on this, that the drafting is really the key, because these restrictions do turn on whether or not they're well drafted and whether or not the wording accurately represents what the restriction you're trying to impose and it is a reasonable restriction. But when you get it right, the remedies for enforcing restrictions can be very useful. They can range from court injunctions to stop, for example, an employee competing or carrying out a certain act, or damages as well, if you can show that an employee's actions in breach of restrictions have caused you a certain level of damages. So looking a bit further at the restrictions in the UK, a few years ago it did look as though the government may be looking to abolish restrictions in the UK. They did consult or launch a consultation on the issue because they were thinking that maybe restrictions were stifling innovation and flexibility in the workforce. This was put up to consultation, but in the recent Taylor report on modern working, they did quietly drop the idea and have acknowledged that restrictions are necessary for employers to protect their interests. So at least in the medium term, they are here to stay. And as Paul mentioned, this is a constantly evolving area of law. It's an area governed by common law, which means that there are case law going through all the time that are amending and varying what the current law is. And because of the nature of common law, when new positions of law are applied, they are applied retroactively. So even if when you apply restrictions and when you implement them, they are at the time compliant and reasonable. If the law then changes, even though that wasn't the law at the time they were implemented, the restrictions could still be found to be unenforceable. So really, the key point is that you need to be reviewing your restrictions regularly and making sure they're keeping up to date with the current law. So just to talk briefly about the example that Paul mentioned at the start of the section, the current case that's working through the courts, which is the case of Tillman and Egon Zender. Paul mentioned we're currently awaiting a Supreme Court decision. And that could change the position, or it could uphold the Court of Appeal's previous decision. So just very, very briefly, on this case, the employee, Ms. Tillman, was employed under fairly standard restrictions, including a non-compete. The contract stated that while she was employed, she was not prevented from holding small shareholdings in other companies, including competitors. However, it was silent on this issue of shareholdings post-termination. So therefore, the employee argued that because it was silent on this, it was effectively preventing her from holding small shareholdings, so 1%, for example, of a company, so even a competitive company, and that in doing so, it was unduly wide and so should be unenforceable. And the Court of Appeal effectively agreed with her and said that without this exception, without a clear exception in the restriction saying the non-compete restriction will not stop you from holding a small shareholding, and it's usually capped in other companies, then it will be deemed to be too wide and so unenforceable. So as things currently stand, any non-compete clause or restriction that does not include a small shareholding exception does risk being enforceable. So we do await the Supreme Court judgment on this to see whether or not they will uphold this position or whether they actually will overturn the Court of Appeal's decision and say that this exception isn't necessary. But it is potentially a decision with a very large number of very large impact, because it could mean a large number of restrictions are potentially unenforceable. So it really reinforces that regular review of your restrictions is very important, and to make sure that they are up to date with current law and stand the best possible chance of being enforceable. And also, when changes are necessary, you should be thinking about the timings that you introduce these changes. To put in place new restrictions or change existing restrictions in the UK, employees do need some sort of extra consideration. So it's common for changes to be made, for example, around pay review time, so that you can link it to any increase in salary to give you that consideration. So turning briefly to continental Europe, the first point to note is that when you're enforcing restrictions abroad, it's the laws of the country that enforcement action is taking place in that will apply. For example, if you've got a UK former employee that then moves to Germany and starts, for example, competing with you in breach of their UK restrictions, then you would need to go to the German courts to enforce those restrictions, and the German court would apply German law to that situation and look at whether the restrictions are enforceable within German law. So it's important to know what the laws of the country are you're looking to enforce in, and how they apply to your current existing restrictions. And the laws on this topic do vary quite significantly country to country. So it is very important to get local advice whenever you're trying to implement restrictions in any EU country, and not just assume that the laws of your country will apply to those restrictions. However, broadly, it is possible to enforce restrictions in the UK, in continental Europe. As a rule of thumb, they are less open to doing so than in the UK, and certainly compared to the US. But in principle, it is possible. So as I said, the laws around this topic do vary significantly from country to country. So you do need to seek local legal advice. But I've set out here some broad issues that you do need to be aware of when looking to implement restrictions within continental Europe. So length to begin with. Effectively, for the most part, this is the same principle as in the UK, i.e. that the length of the restriction must be justifiable in the case of each individual employee and, where possible, tailored to that particular employee. However, a lot of countries in at least Western Europe do allow longer periods than in the UK. Potentially, for example, France and Spain, you can potentially justify restrictions of up to 2 years in certain cases. And then similarly, on the scope of the restrictions, they must, as in the UK, go no further than was absolutely necessary to protect the company's interests. And you need to take into account various factors when deciding this, such as what activities you're looking to restrict, what the employee has done whilst with you, and also the geographical scope of the restrictions. So one of the big differences between the UK and most continental European countries is the issue of compensation. So in the UK, it's not necessary to compensate your employees for the period that they are restricted. But in most or many EU countries in continental Europe, it is a requirement that employees are compensated for periods that they're restricted. The exact level of compensation varies between countries. So, for example, in France and Germany, often it's 50% of the employee's former salary. In Spain, it can be up to 60% of the former salary. And this obviously can have a large financial impact on you, depending on the employee's salary, and really means that you need to be confident that the restrictions are necessary. It's worth noting this usually does only apply to non-compete restrictions, but sometimes it does apply to other restrictions. For example, in France at the moment, there is a question over whether non-solicitation restrictions should also be compensated. And then collective bargaining agreements. This is something not an issue that really is applicable to the UK much, but it is common in continental Europe. And if you do have a CBA that applies to your workforce, often these can either include restrictions themselves or limits on what restrictions you can apply. So that's definitely an area that you should be looking at when you're trying to introduce restrictions. And then finally, always to be aware of any specific execution requirements in continental Europe, because they do exist. For example, in Germany, there is a requirement that a lot of documents, including restrictions, are signed wet ink. So, for example, online and e-signatures aren't sufficient. So this is something to be aware of and get local advice to make sure you are compliant.
Great, thank you, Michael. And from non-competes, we move to a very different but extremely topical issue, which Katie Davenport is going to take us through, and that is talking through metoo in Europe and workplace harassment and some other issues in relation to gender, which have become increasingly prominent.
Thank you, Paul. So more generally, metoo has come about in the UK at a time where gender equality has really come under the spotlight. So we thought we'd start with an overview of the gender pay gap reporting, which, as I'm sure you're all aware, is the second annual reporting deadline is approaching quickly. It's on the 4th of April this year. And I'm sure the press will be likely looking to be able to draw comparisons from last year's to this year's data, because it's the first year in which we've really had the ability to compare changes that have been made and see how that matches up to any explanatory commentary that's been given by an employer. Apparently, so far, about a fifth of employers who are due to report have reported to this date, of which about 50% have shown a reduction
in their gender pay gap, which so far is showing only a slight decrease, which is perhaps not surprising given that it's only been 12 months. But apparently median pay gap last year was 11.8%, and this year so far it's about 11.1%. On the same topic, so last week it was reported that Women's Pay Day, which is where women effectively work for free for the first 2 months of the year. So Women's Pay Day was reportedly on the 6th of March, which is incidentally 2 days before International Women's Day. And along the same lines, there's a cross-party group of MPs who have formed a movement called #PayMeToo in relation to gender pay gap reporting obligations, which has a website which is encouraging women to share their stories about gender pay gaps within their employer, and also gives tips on how to hold their employers to account. So potentially something to watch out for in light of the gender pay gap reporting deadline that's coming up, and just an indication of the overarching awareness that's increasing amongst employees as to what's considered fair. Reminder about the gender pay gap reporting. So it's mandatory for all employers of 250 employees or more. There have been suggestions from the Department for Business, Energy and Industrial Strategy that changes should be made to the legislation, such as reducing the size of employer to those with 50 employees or more. And they've also suggested that the mean and median pay and bonus gap, which is currently reported in quartiles, should be broken down further into potentially deciles to make for more meaningful figures. They've also suggested that an explanatory narrative should be made compulsory. However, so far the government hasn't taken on board any of these changes to the effect that they've changed the legislation. So this year will still just be reporting on the median pay and bonus gaps in quartiles, but potentially something to watch out for. On that note, a consultation closed recently on the introduction of ethnic pay gap reporting. So that the outcome of that is something that everybody needs to be watching out for, because potentially a more complicated obligation to fulfil. Racial diversity is perhaps not monitored in the same way as gender diversity is, so it's something that employers need to be bearing in mind as to how, if that comes into force, they'll be able to comply with the obligations. Finally, the government has been criticised for its gender pay gap reporting strategy, and that the EHRC's enforcement has been seen as toothless, because so far to date no penalties have been imposed. There was apparently 100% compliance with the reporting obligations last year, despite the fact that apparently 12% of employers have reported a 0% pay gap, which is unfortunately statistically impossible. So as it stands, no fines have been levied, but one to watch again as the deadline is approaching. Moving on to more generally women in leadership, and in a more positive vein, the number of all-male boards in the FTSE 350 companies has dropped from 152 to just 3 in 10 years. However, progress has otherwise been fairly slow. CEOs apparently of FTSE 350 companies are more likely to be called Andrew or David than they are to be a woman. And the overall percentage of women on boards is increasingly only marginally year on year. Law Davis did a report in 2015 which set out an aspirational target that the board should be 33% female by 2020. But the Institute of Directors Chair, Charlotte Valeur, has called on FTSE 350 companies to make quicker progress on boosting diversities. Because in order to reach this target by 2020, British companies will need to appoint women to 40% of their board positions to be able to meet this target over the next 2 years. More recently in the news, there was a report published last week by Alison Rose of RBS on behalf of the government, which looked into female entrepreneurship. Currently, only 13% of senior people on UK investment teams are women, and almost half of investment teams have no women at all. So the government is taking a view on how to increase diversity on investment teams with a view to continuing entrepreneurship and continuing London as a hub of startups, potentially after Brexit, as well as the current financial climate. So as a result of this, the Treasury has released a voluntary Investing in Women Code, which requires institutions to consider the gender balance when distributing funding and to publish annual updates on progress. Currently, a lot of major banks have signed up, so again, something to watch in terms of the direction of travel as regards gender diversity. Finally, moving on to the metoo movement and workplace harassment, and what's changed since the movement became into being a few years ago. So we've seen a significant cultural shift. There's an increased awareness of sexual harassment in the workplace, I think all over Europe and across the US. And there's been a potentially slight increase in claims, or at least increase in complaints in the workplace that we're seeing from HR teams. So a reminder of what constitutes harassment. It's unwanted conduct of a sexual nature, and that covers the full spectrum from language touching all the way up to criminal sexual assault. The conduct must have a purpose or effect of violating dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment. The reaction of the victim themselves has a part to play in this. The courts have recognised that victims have different sensitivities and are willing to see a certain degree of subjectivity into what constitutes assault. However, the lack of response by the victim in an employment context doesn't necessarily mean that misconduct does not take place. One point to really bear in mind in light of recent news reports and the metoo movement is that abuse of power or authority can constitute sexual harassment. For example, suggestions that responding to sexual advancement might lead to career progression or rejection might result in harm to career. And that's something that the metoo movement has really brought to the forefront. Sexual assault isn't just what you might see as a traditional definition of it. It's that the power balance between more senior males and junior females that has really been brought to light recently. In July last year, the Women and Equality Select Committee set out a 5-point plan for tackling sexual harassment in the workplace, and the government published its response in December last year. It's been suggested that the government introduces a statutory code of practice to improve employers' compliance to the existing law. This would have the effect, in a similar way to the ACAS code, that it's not a legal obligation to comply with it, but an employer's compliance might be taken into account in the event of a complaint or any litigation. They said that they plan to consult on introducing a mandatory duty, but currently have no plans to implement legislation. The Select Committee also recommended that the time limit for bringing a claim in relation to discrimination or harassment is increased to 6 months from the event complained of versus the 3 months currently. But no timetable has been set out for this by the government. And the government has been criticised by the Select Committee for not going far enough, because currently their draft statutory plan has no provision for the HRC to implement any sort of enforcement. But again, something to watch and potentially something to take into account when updating workplace policies. So moving on to workplace policies, we've seen that HR teams are more active to ensure that correct policies are in place in light of the metoo movement. And ideas for this including specific provisions around the confidentiality on reporting. Employers need to go to lengths to ensure that they can't entirely promise confidentiality, because that obviously can undermine the whole purpose of the investigation. An accused cannot answer potentially anonymous complaints, so it can quite often bring the investigation to a halt. But the employer should make sure it sets out in policy that it will do all it can to protect the confidentiality of the case. Okay, moving on to NDAs. Something again that has been, in light of Weinstein, has been in the news quite a lot. So the Prime Minister in October 2018 vowed to end the use of unethical NDAs and to consult on possible reforms to improve their regulation. Proposals have come out recently which include clarifying in law that confidentiality clauses cannot prevent a person from speaking to the police and reporting the crime, and also requiring a clear description of rights before anything is signed in an employment contract, confidentiality clause or into a settlement agreement. This is, goes hand in hand with a recent warning that solicitors have been given by their regulator to the effect that in employment cases, the NDA should not cover or should not prevent speaking out about sexual harassment, and also should not prevent the employee from disclosing an unlawful act that has not yet happened. So again, one to watch and something to bear in mind if template settlement agreements have been using, that actually the direction of travel at the moment is such that courts are taking a really unfavourable view on employers who are attempting to restrict employees talking about their sexual harassment later down the line. And on that note, that wraps up this one. And so if you have any questions, feel free to submit them in the box on your screen.
Okay, and we have time for a couple of questions. And firstly, Mike, Adam is asking about restrictive covenants in employment agreements and how flexible you can be on the drafting of the time period.
Yeah, sure. So I think the exact question is whether you can have wording in the restriction to effectively say that the length restriction is automatically changed in accordance with what's legally permissible. So having wording to the extent of the restriction is X months or such lesser periods of time that is legally permissible. I'm not aware of this of wording like this being tested in the courts, but I would say it was unfortunately be highly unlikely to be enforceable for two reasons. Firstly, the courts, one of their main priorities is having certainty for the employees on exactly what they're restricted on doing and for how long. So to have some wording in a restriction that would potentially change the length of restriction that's included in the contract that the employee agreed to, I think would create too much uncertainty for the employee for the court to accept. And then also the question of what is legally permissible is obviously a very hard, it's quite a difficult question to answer. So having wording that is kind of that vague to an extent, I think wouldn't be seen as precise enough for the courts to accept. So I think unfortunately the answer to that is most likely no. That wouldn't be enforceable in the UK, and actually it is unfortunate. You would have to just keep updating the restrictions to keep them in line with current law. And also one thing we didn't mention in the presentation is that the enforceability of restrictions are judged at the time that they're entered into. So, for example, if you have a junior employee who comes to you, joins you, and you put in place restrictions, if they leave when they're more senior and you're trying to enforce those restrictions, the courts will look at the whether or not those restrictions were enforceable at the time that the employee entered into them. So, i.e., at the time they first joined in a more junior position. So even if they may later be more maybe enforceable for when they were in a senior position, if they weren't reasonable for the junior position, they would be deemed to be unenforceable. So also, it flags that you need to be not only keeping them updated with current law, but also making sure as an employee progresses through the company, that you're making sure their restrictions are updated and reflect their current position.
Great, thanks, Michael. And Roxanne, Kimberly has asked about BREXIT immigration clinics.
We can send you some more information about that, Kimberly, but essentially what some of our team are doing is they are going into various teams within companies to provide specific information to EEA nationals that are concerned about their right to remain to live and work in the UK post-Brexit. So it entirely depends on what you would want from them, whether you would want them to deliver a webinar or a seminar to your team as a whole, or whether you'd want them to provide these more tailored one-on-one clinics where they can answer individual employees' queries. But if you let us know, we can always provide you more detail in relation to that.
Thank you. And that's all we have time for today. Thank you for joining our webinar. You've got the contact details on the slide there, which will all be emailed out to everybody who's signed up anyway. Feel free to contact any of the speakers with any follow-up questions directly, and I hope you will join us for our next webinar. As Roxanne mentioned, there is a webinar specifically on Brexit and immigration in 2 days' time if you'd like even more detail on that topic. So thank you again for joining.